Hello, my name is Kahari Whitehead, and for my first case, I will dive in about the Grand Theft Auto murderer. This young man killed 3 people, and his reasoning of doing it was from PTSD of playing Grand Theft Auto. Devin Darnell Thompson was convicted of murdering 3 Fayette police officers, Arnold Strickland, James Crump, and police dispatcher Leslie Ace Miller after he was being booked for Grand Theft Auto. The state's evidence showed that at approximately 6 a.m. on the morning of June 3, 2003, Tim Brown, a paramedic with Fayette Medical Center, was dispatched to the Fayette Police Department. Brown testified that when he approached the station, he saw Mueller's body lying on the other side of the door to the police station, which was locked. After he forced his way inside, Brown said he discovered that Mueller had been shot in the head. He proceeded through the building and found the bodies of Officer Crump and Officer Strickland. He said both had been shot in the head and were lying in a pool of blood. The testimony shows that around 3 a.m. on the morning of June 3, 2003, Officer Crump and Officer Strickland approached a vehicle parked in a lot of a local restaurant and found Thompson asleep in the vehicle. The dispatcher informed them that the vehicle had been stolen and officers took Thompson into custody. While the officers were booking Thompson, they discovered that a dry cleaning business near where the car had been stolen had been burglarized and clothing had been taken from that business. A shoe print had been discovered at the scene of that burglary. The officers removed Thompson's handcuffs in order to take his fingerprints and removed one of his shoes to get a shoe print. While Thompson was being fingerprinted, he took Strickland's .40 caliber service pistol and shot Strickland in the head. Thompson then crossed the hall and shot Officer Crump in the head. As Thompson walked toward the exit of the police station, he encountered Mueller. He shot Mueller multiple times and left the station. Thompson attempted to re-enter the station when he realized that one of his shoes was still inside, but the door had automatically locked when it closed, and he was unable to re-enter. Thompson proceeded to the Fayette Fire Station, which was located in the same building as the Fayette Police Department, and told 2 firemen that something bad had happened up front. Thompson then stole a police cruiser and fled the scene. He was arrested later that day near Columbus, Mississippi. The pistol Thompson had taken from Officer Strickland was found in the police cruiser. At his trial, Thompson did not dispute the fact that he shot and killed those 3 officers. Instead, his defense was that he was not guilty by reason of mental disease or defect. Thompson presented expert testimony to the effect that he was suffering from post-traumatic stress disorder, or PTSD. He testified that at the times of those murders, he was in a dissociative state. Therefore, he argued he was not reasonable for his actions. The state countered Thompson's expert testimony by presenting expert testimony to the effect that Thompson was not in a dissociative state when he committed the murders. The jury convicted Thompson of 6 counts of capital murder. A separate sentencing hearing was held, and the jury recommended by a vote of 10-2 that Thompson be sentenced to death. A pre-sentence report was prepared, and a separate sentencing hearing was held before the circuit court. The circuit court found 4 aggravating circumstances. The first one was that the murders were committed during the course of a robbery. The second was that the murders were committed for the purpose of avoiding or preventing an arrest or effecting an escape from custody. The third was that the murders were committed to disrupt or hinder the lawful exercise of a governmental function or the enforcement of laws. And the fourth and last one was that the multiple murders were committed pursuant to one scheme or course of conduct. After weighing the aggravating circumstances and the mitigating circumstances, the circuit court followed the jury's recommendation and sentenced Thompson to death. This appeal, which is automatic in a case involving the death penalty, followed right after. Because Thompson has been sentenced to death, the court must review the lower court proceedings. It states that in all cases in which the death penalty has been imposed, the Court of Criminal Appeals shall notice any plain error or defect in the proceedings under review, whether or not brought to the attention of the trial court, and take appropriate appellate action by reason thereof, whenever such error has, or probably has, adversely affected a substantial right of the appellant. The most interesting appeal that Thompson gave in this court was his defense that he was not guilty by reason of mental disease or defect, and he testified that he had PTSD and he was in a dissociative state during those crimes. This sounds pretty basic at first, but his reasoning on why he was in this state is what made this case famous. They had even brought in doctors on this case to do studies on him as well to prove his defense. They brought in Dr. Marion Rosenzweig, a forensic psychologist, and Dr. Charles Nevels, a clinical psychiatrist, to testify that Thompson was in a dissociative state on the night of the offense, and he unconsciously reverted to the scripted behavior he learned through years of almost daily prolonged and repetitive video game playing. Specifically, he says, the video game Grand Theft Auto. Yep, you heard it correctly. Grand Theft Auto, Vice City to be exact. In his defense, Thompson presented the testimony of Dr. Rosenzweig. She testified that she conducted a series of psychological tests on Thompson at Taylor Hardin Secure Medical Facility. She said that she spoke to Thompson 4 times in 2003, 4 times in 2004, and twice in 2005, and that she completed the Personality Assessment Inventory Test, the Rorschach Ink Blot Test, and a Trauma Symptom Inventory Test. It was her opinion that Thompson suffered from PTSD. Dr. Rosenzweig testified that PTSD is the most severe anxiety disorder, that typically people with this illness have experienced a traumatic event or a series of traumatic events, and that some people with PTSD are unable to function. She testified that Thompson has difficulty making decisions, that he acts impulsively, that his ability to think properly is impaired, and that Thompson's severe mental illness rendered him incapable of appreciating the nature of his actions at the time of the alleged incident, because he was in a dissociative state. Through all of the appeals and evidence that supported it, the jury still found him guilty. On February 17, 2012, the Alabama Court of Criminal Appeals upheld the conviction of Devin Darnell Thompson. The court, in a 5-0 decision, believed that Devin received a fair trial. They also believed that the death penalty was the appropriate sentence. The next case I will discuss will be a federal case that also tackles a PTSD legal issue, but not for capital murder, but in the drug trafficking ring. The case involves 3 defendants, but only one of them testified on the count of PTSD, so I will be focusing majority of the details on that person. In the summer of '92, Jefferson Moran, a special agent with DEA, learned from a confidential informant, Ramon Malave, that defendant Carlos Lugo Lopez was interested in selling kilogram quantities of cocaine. On instruction from Moran, Malave confirmed Carlos' interest in a phone conversation and later called to negotiate the purchase of 2 kilograms of cocaine. Malave told Carlos that he could page Moran, whom Malave said would handle the money, when he was ready to make the transactions. Carlos had Moran paged. Carlos left a message for Moran that the contracts were ready and that he should drop by Carlos' house to pick them up. Malave went to Carlos' residence, where he met the supplier, defendant Luis Cartagena Carrasquillo. Luis left, saying that he would return right away with the drugs. Luis later returned with defendant Jose L. Figueroa Garcia and a bag. They went to a room at the rear of the carport, where Luis opened the bag and took out a kilo of cocaine. During phone conversations between Moran and Malave, while Malave was at Carlos' house, Malave said 2 men had arrived to sell 2 of the 4 kilograms of cocaine in the bag. Carlos asked Malave to call his partner Moran to come and put up the money. In a round robin, Carlos kept insisting that the money be brought to his house, while Malave, on instructions from Moran, tried to lure Carlos to San Juan with promises he would be paid there. At some point during a series of pages and telephone calls, Luis and Jose left to sell 1 of the kilos to another. When the 2 returned, Carlos and Malave were still talking about where the sale would take place. Luis got upset with the delay and left in the car with Jose. Law enforcement agents shadowed the car driven by Jose and saw Luis get out of the car carrying a tan bag. When the agents approached him, he got back into the car and fled with Jose. A car chase resulted, ending in a public housing project. The 2 men fled by foot and were ultimately arrested. Luis, who had the tan bag in his hands when he abandoned the car, did not have it when he was arrested. Agents later found it in a trash can in the area where they first fled on foot. It contained 3 kilograms of cocaine and $12,900 in cash. On June 17, 1992, a grand jury returned a 4-count indictment charging the 3 defendants, which included aiding and abetting each other, possessed with intent to distribute some grams of cocaine. Carlos also got hit with 2 counts of using a telephone in furtherance of drug distribution and violation. The trial started on November 3, 1993. After 4 days of testimony, the defendants requested and were granted a mistrial. Luis and Carlos moved for dismissal on double jeopardy grounds. The district's court denial of the motion was appealed. While that appeal was pending, this case went to trial for the second time on February 4, 1994. The defendants were found guilty of all counts. The appeals from the conviction were consolidated with the appeals from the denial of the motion to dismiss on grounds of double jeopardy. Carlos argues there was an error in the exclusion of his proffered expert testimony that he suffered from PTSD and his attempts to base an insanity defense on PTSD. After the first mistrial, Carlos filed a written motion on January 11, 1994, giving notice of a PTSD defense. The motion indicated that Carlos would present the testimony of both Luis Falcon Torres, his caseworker at the Puerto Rico Vietnam Veterans Assistance Program, and as a yet unnamed expert on PTSD. The motion was discussed on February 1, 1994, in a status conference, and the judge decided that this motion passed and it would be resolved at trial. Fast forward later into the trial. The expert's report stated, in pertinent part, Carlos justifies his behavior with his special army training and his Vietnam experience, when his main problem is his poor judgment. He cannot anticipate the consequences of his behavior most of the time. His schizophrenia makeup adds to his difficulties. Luis's psychiatrist's diagnosis was that cocaine and heroin use independency, together with his schizophrenia makeup, explains his grandiose and delusional behavior, especially in relation to the informant during the investigation. The report concluded there is no doubt that the patient meets the criteria for a PTSD patient and was having delusions when he was being intervened by a DEA confidant, and it is confirmed in a report prepared by the DEA agents. At the time of the intervention of the DEA representatives, Carlos, because of his delusions of grandeur, had a significant mental disease and was unable to conform his conduct to the requirements of the law. According to the court, they believed that there was nothing in the psychiatrist's report which suggests that the defendant did not know or could not appreciate that selling cocaine was wrong, and there is no evidence in the report or otherwise that Carlos was suffering from any effects, delusional or otherwise, on the dates when the crimes, the drug transaction, and the telephone conversations actually took place. Ultimately, Carlos got conviction affirmed on his counts. In conclusion, I believe that both cases were judged correctly and received the right verdict. For the Grand Theft Auto murderer, I don't believe that there is anything that could justify a man going on a killing spree and then blaming it on a video game. I played violent games my whole life, and that has not made me a violent person. For Carlos's case, I do agree with the court's viewings that he may suffer from PTSD, but it didn't have any specific effects on his choices during those crimes he committed. My first question is from the Grand Theft Auto trial. Do you believe that a person can actually suffer from PTSD from playing a video game? And explain your reasoning. My second question is from the Carlos case. Do you believe that if Carlos would have testified PTSD earlier in the trial, that he could have gotten a better verdict? Explain your reasoning. These are the picture citations that I used for my presentation. These are the references that I used for my presentation. Thank you all for tuning in to my presentation, and I hope you enjoyed it.